Dr. Rafa, a Foundation Year 1 junior doctor at Kettering General Hospital NHS Foundation Trust, was asked to produce her travel pass when entering the automated ticket barrier at King's Cross Station on the 1st of February 2018. She produced a Freedom Pass issued to her sister, which gave the holder free travel on London Underground. The General Medical Council alleged that Dr. Rafa knew that the pass did not belong to her and acted dishonestly by using it, giving an untruthful account to the ticket inspector, and later making untruthful statements to Transport for London. Dr. Rafa denied the allegations, stating that she used the pass unknowingly. On the 5th of July 2018, she was convicted of entering a compulsory ticket area without a valid ticket, fined £200, and ordered to pay compensation of £396.90 for travelling without a valid ticket on 80 occasions. Dr. Rafa was working as a Foundation Year 2 doctor at Leicester Royal Infirmary at the time of the hearing. At the outset, the allegations related to the conviction were accepted by the doctor. The tribunal needed to determine if Dr. Rafa knowingly used her sister's Freedom Pass and whether her actions were dishonest between December 4, 2017 and February 1, 2018. The tribunal also needed to determine if Dr. Rafa provided TfL with statements that she knew to be untrue and whether she acted dishonestly in doing so. The GMC presented evidence from Ms. B, a revenue control inspector for TfL, while Dr. Rafa provided her own witness statement and supplementary statement, as well as oral evidence. The tribunal also considered documentary evidence such as email correspondence, information from TfL, professional and personal testimonials, Dr. Rafa's CV, and copies of 360-degree reviews. Additionally, an email from Lavender Hill Magistrates Court dated the 7th of August 2018 was provided, which enclosed Dr. Rafa's written guilty plea, memorandum of conviction, and other supporting documentation. The tribunal considered the doctor to be less credible compared to the TfL inspector and preferred the inspector's evidence and thus found the dishonesty allegations proven. The GMC submitted that Dr. Rafa's fitness to practice is impaired due to her misconduct and conviction, with the former being more serious as the tribunal found her use of the pass to be dishonest. They referred to good medical practice and stated that a finding of misconduct is necessary to protect patient safety and maintain proper standards in conduct in the profession. The GMC argued that despite the lack of direct connection between Dr. Rafa's conduct and her work as a doctor, her pattern of repeated dishonesty poses a risk to patient safety, and her lack of responsibility and insight makes her an untrustworthy witness. They concluded that the seriousness of the findings warrants a finding of impairment to protect the public and maintain public confidence in the profession. The doctor's lawyer argued that Dr. Rafa did not intentionally deceive anyone and that her behavior was an isolated incident of poor judgment. The counsel cited evidence of Dr. Rafa's good character and trustworthy behavior in the workplace, as well as her efforts to gain insight into her actions through reflective writing and seeking training. The counsel argued that Dr. Rafa's conduct can be remediated and invited the tribunal to find that her fitness to practice is not impaired. The tribunal considered whether Dr. Rafa's fitness to practice is impaired due to serious misconduct. The tribunal was advised to take into account Dr. Rafa's conduct at the time of the events in question, any relevant factors since then, and the objective of protecting the public, maintaining confidence in the profession, and promoting professional standards. The tribunal is not required to reopen the findings of fact, but it may consider whether Dr. Rafa accepts the misconduct and understands its gravity. The tribunal may also take into account any lack of candor or continued dishonesty by Dr. Rafa. The GMC agrees that the tribunal can consider Dr. Rafa's maintained denial of the misconduct.
The tribunal noted that the case concerns Dr. Rafa, who used her sister's Freedom Pass to enter the compulsory ticket area on 80 occasions, knowing it was not hers to use. She then produced the pass to a Transport for London revenue control inspector and lied about it being hers. Later, she submitted a statement to TfL, in which she made untrue statements about the incident. The tribunal found that her actions were dishonest and breached the fundamental tenets of good medical practice. The tribunal concluded that her conduct amounted to misconduct and fell below the standards reasonably expected of a doctor. The tribunal considered several factors, including whether Dr. Rafa's actions had put patients at risk of harm, whether her actions brought the medical profession into disrepute, and whether she acted dishonestly. The tribunal noted positive feedback from colleagues and patients and Dr. Arfa's statement expressing remorse for her actions. While the tribunal acknowledged that it is difficult to remediate dishonesty, it did not take specific steps to address this element due to Dr. Arfa's continued denial of her dishonest conduct. Overall, the tribunal concluded that Dr. Arfa's misconduct had breached fundamental tenets of the medical profession and brought it into disrepute, and as a result, her fitness to practice was currently impaired. Dr. Arfa's fitness to practice has been deemed impaired by the tribunal due to her conviction, despite it being a strict liability offense. The tribunal is of the view that conviction is related to serious misconduct, which has contributed to the impairment of her fitness to practice. The counsel, representing the GMC, addressed the tribunal on the documents contained in the defense sanction bundle. She submitted that Dr. Arfa has been extremely limited in her disclosure, maintaining that her use of the pass was unintentional. She invited the tribunal to consider carefully the emails, which she submitted demonstrate that Dr. Arfa has no insight into the seriousness of her position. The counsel referred to the sanctions guidance, February 2018, and submitted that the reputation of the profession as a whole should be at the forefront of the tribunal's mind. She reminded the tribunal that any sanction imposed should be proportionate, weighing the interests of the public against Dr. Arfa's interests. The GMC submitted that Dr. Arfa's registration should be suspended and referred to paragraphs 112 to 119 of the sanctions guidance that deal with conviction cases and invited the tribunal to consider whether the doctor's registration should be restricted to protect the public or maintain standards and the reputation of the profession as a result of the conviction. She concluded that only an order of suspension will protect the public in this case. The counsel, representing Dr. Arfa, argued that the tribunal should take into account the impact a suspension would have on Dr. Arfa's career as she is at an early stage and would lose her specialist training number. She highlighted Dr. Arfa's dedication to her career, involvement in audits and research, and potential for the future. She suggested that conditions could be imposed instead of suspension to manage any risks to patient safety, and if suspension was deemed necessary, a period of 3 months would be appropriate to allow Dr. Arfa to attend ethics courses. She also reminded the tribunal that Dr. Arfa had already received punishment through a public finding of impaired fitness to practice and a criminal conviction. The tribunal considered Dr. Arfa's misconduct to be serious, involving repeated dishonesty which breached fundamental tenets of good medical practice. The tribunal identified lack of insight as an aggravating factor in her early career stage, lack of previous FTP history, developing insight, and no harm caused to patients as mitigating factors. The tribunal also noted that dishonesty related to matters outside clinical responsibility is particularly serious as it can undermine public trust in the medical profession. Evidence of clinical competence cannot mitigate serious and/or persistent dishonesty. The tribunal has considered whether to take no action against her, impose conditions on her registration, suspend her registration or erase her from the register. The tribunal found that taking no action or imposing conditions would not be sufficient or appropriate, and erasure would be disproportionate. The tribunal therefore suspended her registration for 8 months. The suspension is intended to maintain public confidence in the profession and uphold proper standards of conduct. The suspension will allow Dr. Arfa to develop insight into her misconduct and reapply for specialist training in 2020. The tribunal ordered a review of Dr. Arfa's case before the end of her suspension. At the review hearing, Dr. Arfa will need to demonstrate how she has remediated her misconduct and provide evidence of attending courses, a reflective statement, and updated clinical skills and knowledge. Dr. Arfa can also provide any other information that she believes will assist. The tribunal suggested that she may benefit from being mentored by a senior colleague. The tribunal did not impose an immediate order of suspension,